Mm. All right. Looks like we have a number of people here. So if we could, Mr. Vogel, would you mind doing a roll call?
Certainly, Madam Chair. Ms. Dawson?
Present.
Mr. Esme?
Present.
Ms. Evans?
Present.
Mr. Tatum?
Present.
Ms. Williamson? Ms. Williamson. All right, Madam Chair, the 5 members are present. A quorum is present.
All right. So just first item, as we've typically done, is that a copy of the February 7th meeting minutes are posted to the task force website. If there are any corrections or any other comments on those, if you could speak up now. Hearing none, then I'll declare the minutes approved. So today, first item is Mr. Vogel's going to present us with some of his ongoing research, and then after that, we can begin some of our discussions.
Thank you, Madam Chair. And if you don't mind, I'm going to share my screen here. I have a little presentation prepared. Can you all see my my PowerPoint?
Yes.
All right, awesome. Thank you. All right, so Madam Chair and members, I've been researching federal background check requirements, and I started that research looking into the Adam Walsh Act in particular. And essentially what I found was there are some really great resources put out by the U.S. Department of Health and Human Services, those documents I sent you earlier this morning, which summarize these statutes. And essentially the Adam Walsh Act and several other statutes essentially all reflect back on the text of Title 4E of the Social Security Act. So the Adam Walsh Act, for instance, essentially expanded the requirements for states to conduct background checks in cases of child fostering and that sort of thing, but didn't implement specific disqualifying crimes in itself. Instead, that expansion of background checks reflects back on the list of specific disqualifying crimes in Title 4E. So the specific citation for Title 4E for the Title 4E disqualifying crimes is 42 USC section 671 A20A 1 and 2. So 1 is a list of permanent disqualifying crimes, which I've broken the text down in this Frankenstein-y way just because it's a little easier to read. Felony convictions for child abuse or neglect, for spousal abuse, for a crime against children, including child pornography, or for a crime including violence, including rape, sexual assault, or homicide, but not including other physical assault or battery. So in cases of felony convictions being found in a background check, that would disqualify permanently an applicant for instance, child fostering. The next section, which is number 2 of that same citation, is a 5-year disqualification for essentially drug crimes as well as physical assault and battery. Now, compare this, for example, to that Iowa statute that I was discussing in the last meeting, Iowa Code 237-8. And we can see that the specifically enumerated crimes in that statute are essentially the same as the federal crimes. The only difference I could see here is that it lists a permanent disqualification for any forcible felony rather than forcible felonies other than assault or battery, which is assault or battery being a 5-year disqualification at the federal level. But otherwise, the Iowa legislature appears to have added these federally mandated crimes to what's otherwise a pretty underspecified statute, as it were. Ms. Evans?
Well, can you define forcible felony for me?
That's an excellent question.
Would it be like a crime against a person, what we would consider a crime against a person here?
In Iowa law? I would assume so, but I can double check that and see if there's a precise definition in Iowa law.
Thank you.
Yep. All right. So yeah, that's essentially my research, that these federal laws, including the Adam Walsh Act, reflect back on Title 4E, and in the comparative state research, we can see states responding to this federal requirement. I should note that, of course, Minnesota also is subject to Title 4E. And this has come up in the discussions of the disqualification committee and in some of the presentations that the Department of Human Services has given. Chair Geffen and Vice Chair Evans have actually asked DHS for a list of crimes or conduct mentioned in 245C that reflect a federal requirement like Title 4E. So hopefully getting that list will be helpful for the work of the task force going forward. But so yeah, that's essentially, oh, Mr. Esme.
So just to be real clear, this is going to only apply, this sort of federal baseline requirement is going to only apply to adopting and fostering. Is that right?
Correct. In the case of Title 4E.
Okay. And do the federal statutes offer any remedy?
I didn't see one. No. I can continue researching that, though. I was principally trying to get this list of disqualifying crimes, so I didn't do a deep dive into remedies.
And is there anybody on here? Title 4E is funding, correct?
It's funding, but these disqualifying crimes disqualify. Essentially, they tie funding to states enacting these disqualifications, as far as I can tell. Mr. Esme, did you have another question?
Yeah, I guess I just wanted to, I think we're on the same page, but just to nail it down, I think we need to figure, for the purposes of our subcommittee and our recommendations, I think we need to figure out if these sort of baseline background check requirements and disqualifications stand in the way of Minnesota putting in, some kind of remedy that would offer someone, to waive, to be able to show that they're qualified to adopt and waive, the disqualifications.
Yeah, that's an excellent point, Mr. Esme, and I'll keep that in mind as I continue my research. My understanding from, sorry.
So I was going to say DHS might already know the answer to that, right? Because some of these are non-permanent disqualifications under, like the, I think, like the domestic abuse one could be a, misdemeanors, 7-year, I think. I don't know. I'd have to go back and look at the federal statute, but.
Yeah, and as I recall from my discussions with DHS, these federal requirements would impact the ability of the remedies group to recommend remedies. Like some of these federal disqualifications would come up with the set aside, et cetera, portion of 245C. That being said, we do have Ms. Cassane from DHS on the call, so I don't know if I want to formally speak for them. And that's just off the top of my head. So just take that with a grain of salt. But that's an excellent point, Mr. Esme, which I'll keep in mind in my further research. And then I did want to note that that part of my research is stemming from resources from the Child Welfare, from the Children's Bureau of HHS. And those documents were very helpful reading for me, and they might be helpful reading for you as well. So with that, I'll stop sharing my slides. But yeah, did anyone have any further questions or
Josh, I just would add, I know Ramsey County, and I know, was it you, Lucas, that said you didn't appreciate Ramsey County in this area? But Ramsey County is actually using kinship care and foregoing the Title 4E dollars and allowing family to do foster care anyways before people are approved, and just foregoing the funding. So the money is tied to the funding. And so Ann Berry was talking about that in a meeting a few weeks ago. So
do you know, Gina, how that works with the DHS background study, right? So like if we imagine that we have someone who could get a set aside, but for being barred under the federal law. Okay.
Yep.
Madam Chair, Mr. Esme, if I might interject, Ms. Sherlock and Ms. Kaser are on the disqualification committee, and this is essentially their topic. They're far more knowledgeable about Title IV-E and Title IV-E compliance than certainly I am, and I think anyone on this call. They might be a resource that would be helpful to call upon.
Okay.
Lucas, was it you that talked about it though? And that maybe it's not the best way to do it?
Well, I do know, I mean, they can be I think, and one of them, I think, also talked about it at another meeting, but they can emergency license a family member, which, yes, you wouldn't have the Title IV-E because you can do that while you're doing the application process. And then ultimately, of course, the idea would be to avoid a bunch of moves for a child. But families can be emergency foster licensed. And then while they do all the background studies and things like that. I think that's what I had mentioned at one point, which was why like Ramsey County sort of saying they forego it. Well, they can by statute. So that is what it is. I guess, and I don't know, I mean, it's interesting, I guess, and where our group is thinking of how much, I mean, a lot of this seems to apply and be tied to federal law, at least for foster care and adoption, but there doesn't seem to be much for like long-term care and treatment facility. I don't know, I feel like that just hasn't been coming up. And well, I'm not, of course, you're doing your thorough research. It just doesn't seem to be coming up as much. And so I just want to make sure we're not missing that, or if there's more we should be looking at with that. I don't know what others think.
My just, 1,000-foot understanding is that the Adam Walsh Act basically applies a higher level of requirements on specifically the foster and adopting that aren't mandated by federal law for the other areas covered by our DHS Background Studies Act. So I think, at least in my mind, how it should work for our group is we need to figure out if federal law bars us from offering a remedy to someone who's subject to the federal law. And then if so, then we're probably stuck with it, at least to some degree. I mean, unless we want to recommend that the state forego federal money, which I don't know if we want to do that. But then we could just sort of cordon off that area and just say, these limits should not apply, anywhere beyond specifically what the federal statute requires for foster and adopting.
Ms. Cassane, do you think that you could find that out for us? I'm guessing the answer is yes. Federal law does bar us from offering a remedy.
Vice Chair Evans, thank you for the question, and members. I'm Emily Cassane from DHS Background Studies. I know our legal department, Background Studies Legal, is preparing a list of federal citations, as Mr. Vogel indicated. I think that will be really helpful. There are a number of federal laws, including, of course, Adam Walsh and the Child Care Development Block Grant, that specify certain conducts. And yes, I think I will double check on the progress they're making on that list, and that should be very helpful to what you're.
So again, you said though, federal law block grants, again, that's tied to dollars, right?
Yes, the Child Care Development Block Grant is the federal authority over child care studies. So they have certain requirements that are tied to significant amounts of funding that the state receives.
What I'm wondering
as a whole, not just the state.
Yeah, I'm wondering then if the way, because right now I feel like the disqualification statute looks at everybody the same, no matter what area you're working in. And I can appreciate the federal funding and that's important. And especially like the foster care dollars, if there's no federal funding, that's additional funds for counties that I just don't see being realistic to try to get around. But like for long-term care facilities and treatment centers, should we be looking at something that treats them differently?
Yeah, one of the things I sent to asking one of the employers is like, I think one of the things we really need to hit on is like, what we're looking at is like risk of harm, which is like potential. And then the actual is the amount of money and training and this workforce issue that we're dealing with right now, which is actual. That's the actual thing we're up against right now. And so, you know, one of the things for us in like remedies is like, how do we, you know, and with disqualification, which isn't this group, but like, how do we show that in like with remedies, and how do we ask for the data that we need to show that from the data group, with the amount of time someone has to ask for, like, we haven't even asked for that data yet, right? The amount of times a specific individual has to ask for a remedy, or like, we haven't even asked for any of that specific information to be able to show the legislature. Like Randy Anderson's had to have a set aside 12 times or something like that over the course of his LADC and his internships and all of that stuff. And so I guess I would really just like to have us, you know, with as long as data is taking, I feel like we maybe have 3 or 4 more data requests that we're going to get before the end of our time together. And so what is it that we feel like is going to be the most impactful for us as the 3 subcommittees, to be able to show risk of harm, to be able to show, is it process, is it, and so I really want us to focus on what is the most important piece of information that because we have a lot of stuff. I sent you an email, Lucas, kind of speaking to this. Okay. And so, because I just am not hopeful that we're going to get a ton more data requests. And so what is the most important thing we need to show out of remedies? Because I think process is one of those things, but we don't need DHS about process. We can get that from the people going through the process to be able to show the arduousness of that and all of that.
Well, and I also just sort of wonder, I mean, one thing that we had talked about was not only obviously the kind of 3 main topics that sort of seem to keep coming up, the preponderance of the evidence standard, the actual permanency list and the years list. And if we recommend changes to those, how much quicker that will allow DHS to turn things around. I mean, if we're changing to where there is no POE or if we're recommending that, just by way of an example, that cuts down on, I'm sure, a certain number if we're reducing the permanency list. Again, I can't help but wonder, would that help expedite and help turn things around faster? And even like, for example, the person who has to get 15 set-asides, I don't know with him what his was, but would that alleviate that too?
Yep.
I do think one thing that I think has sort of become clear as a topic is, how do all of these really apply to a risk of harm?
Yeah.
And that's where, like, looking at the felony, where it's a felony conviction, you know, under the federal one for child abuse, neglect, spousal abuse, crimes against children, like, I get that makes sense. Versus one thing that I know I've brought up before, but just misdemeanor domestic assault, where you can have fear or actual harm and it's a misdemeanor, and this to get to a felony level, you have gone above and beyond that. Yes, I absolutely get that. But most of my clients who have a misdemeanor domestic function just fine in life and would be fine with everybody other than their spouse for that instance. So
Yep.
I just, again, tying it to what's the risk to the public.
Yep. And that was one of the things in the, that I like, so disqualifying crime or conduct, to be able to start looking at those. And then when DHS starts giving people set-asides, is there a point during DHS starting to like give people set-asides that they give people set-asides every time, that we can look at that time frame and then draw conclusions from that? So is it us that we've been tasked with the permanency list?
Yeah, I think so.
Yeah. Do we want to maybe have that as a task to like start looking at that list?
Yeah, well, and I mean, to me, I feel like if the starting point is, wonder if I can pull it up. Apparently I have a lot of things open on my laptop. Do I have the ability to share my screen? I do. Hey, winner. Okay. What is this showing?
Yep, that's it.
Okay. Don't always know what's going to pop up. Okay. So here, I mean, we're looking at, this is the permanent list.
Yep.
I mean, which has many of the ones that I think make sense. Like we're talking murder in the first degree, murder in the second degree, murder in the third degree. The higher level manslaughter, so your first and your second, I can appreciate. Although I don't know if the Adam Walsh really does the has manslaughter, felony. So if we're looking at first or second degree, again, I can appreciate that in that first degree, a weapon's involved and there's substantial bodily harm. Second degree, we're looking at substantial bodily harm. So we're looking at those true, like the bad ones. Felony domestic assault, which I think is in line with Adam Walsh. Child abuse, neglect, crimes against children.
So that's one of the ones where I feel like, so assault in the first degree, yes, assault in the second degree is one where it gets really dicey sometimes because they consider like sometimes it's mace or like it can get really like the way that county like police law enforcement and granted it's the way witnesses and people at the scene and all that stuff, but the way law enforcement writes up the police report and then the way it gets interpreted by the county attorneys can sometimes not be as accurate as we would like it to be. And then people take plea agreements because they're afraid and they don't want to go to jail. And it isn't always in the best interest, right? And so not always. But there have been people who, I have a friend and we could have her come share, but she got into a domestic drunk with her dad and just tapped him on the leg with a baseball bat. And when the police got there, she got super, like, she called the cops pigs and told them to get out of her yard and all that. And they arrested her because of her behavior when her dad just wanted her to go in the house and go to bed. And they gave her second degree assault with a deadly weapon. Like she didn't even leave a mark on her dad. And that's like on her, she was 20 at the time. And so some of those, I just feel like because of the like power of the prosecutor and the way that our system is, like the second degree ones, I feel like sometimes, that's the rest of people's lives.
Yeah,
He's
no, that's fair.
perfect.
Mr. Esme?
Yeah, I just want to jump in. I don't think we should let first degree off the hook for that same rationale either. I mean, these statutes are so broad. There's a pretty well-known Court of Appeals first degree assault case where two friends are basically goofing around near a bonfire, and one shoves the other one with no intent to cause harm, but the shove was intentional. And the way that where assault statutes are set up is there's no requirement that the defendant have the intent to cause the level of harm that is caused.
Yeah.
So this goofy shove that unintentionally, from anyone's perspective, led to the victim here tripping and falling into the fire leads to first degree assault. Or I mean, pretty much any defense attorney will tell you this. I have a case right now where, one punch that was sort of in self-defense, but probably not, a great self-defense claim, just by freak accident led to a level of injury that sustains first degree assault.
Right.
And, it's clearly no intent to cause that level of harm. It was a single punch. It, landing the wrong way can get to that first degree assault. And to me, that's the prime example of why it's a huge problem to not even have a remedy here. And
Right.
that our big recommendation should be that DHS can actually look at the conduct involved and assess the sort of level of culpability of that person's action, and waive it for the tap on the leg with a baseball bat or single punch,
And like after 10 years or whatever, so that there's a span of time, because the way that they are now, the commissioner can offer a set aside after however long, but like there's a bar for a certain amount of time. And then after that time, they can apply for a set aside, like a different solution to it than just permanent, that there's a bar for a period of time or whatever. Like that's
well,
what
and I
we're
wonder
doing.
though, would under the Adam Walsh, it seems like the assault, either first or second, would those be more the 5 year, which is much different. And I feel like might, rather than do we even need a remedy then if they move down to the 5 year? And I'm just throwing it out there. I don't know.
Well, there's sort of two questions, right? I mean, question one is, does first and second degree assault stay in the permanent disqualification tier? And then question two is, which, if any, of the offenses that are in the permanent disqualification tier should have a set aside remedy available to them? And I would say my recommendation would be that a set aside is at least theoretically available to anybody, because I believe that, that people can change and should be able to show that. Now, it doesn't mean that everyone's always going to get a set aside, but for people who can prove that it's safe for them to work, I think DHS should have that discretion, and they used to. And my recommendation would just be that we give it back. And then, but to the first question of which stays in the permanent disqualification tier, I think we could look at that too, but that question almost seems more appropriate for the other subcommittee.
John was thinking that they had so much other stuff to do that we could do it instead.
And I will tell you, as someone who's in that subcommittee, that I think there are some very differing views in that one, that I think they're going to have a more difficult time. There's a lot of focus on the juvenile piece, and there are very differing views on that I don't honestly know how far they're going to get. And I'm not saying that to be bad. They're going to have much more debates, and I don't know how long it'll take them to reach any sort of a consensus.
Yep, it's better here.
Versus our group, where I think it's just a matter of sort of, again, we're looking at it kind of that 10,000 foot view and sort of what makes sense. And again, I think for us to look at right now it's really what makes sense for recommendations. And I don't know if we, for our March 1st report, need to be so much ready to say, these are the ones that we think absolutely should be permanent.
Yep,
Versus
we do.
a recommendation of, we think the permanency list is too broad and
Yep.
should definitely be reduced to more closely follow, let's say, the Adam Walsh Act.
Yeah.
I feel like, I don't know that we need to be so much redlining or crossing things out versus that bigger view.
I agree. We just need to identify the problem so far.
Yeah.
Yeah.
And right
I mean,
now,
I think the big problem is this is too much, and this is not related to really the risk of harm.
Yes. And that we are asking people who have been disqualified to obtain remedies repeatedly for far too long, right?
Yeah.
So I think I said that terribly, Will, but like that's part of the problem, right? Which is clogging up DHS with the same people over and over again. It would be great to have that data, like, and we kind of do, right? Because they gave us the data at the very first, and I was a little surprised by it actually. If you look at the very first, I wrote it down actually, at the very first meeting where they did a presentation, the number of unique set-asides, the number of unique disqualifications compared to the number of disqualifications as a whole, that the number was very different. So it was how many people compared to how many overall disqualifications. It was a pretty wide gap.
Mhm.
And so I think that speaks to something, right? That they're disqualifying the same people over and over again. And they did the very first DHS presentation included that data. And so I think we could speak to that, right? That we're doing the same folks over and over again.
Mm-hmm. Yeah, I think that makes sense. Go ahead, Mr. Esme.
I was gonna say, I feel like that point actually sort of fits really nicely with some of the other things we've identified about the set aside process or the reconsideration process just being really cumbersome and difficult for people to navigate.
Yeah.
Which is one of our three big buckets already, right?
Yes.
Do you agree that sort of fits well there, Gina?
Mm-hmm.
Yeah. Okay.
Yeah, I mean, our three big buckets were the preponderance of the evidence, the permanency, and then just sort of our years list, and then the appeal process itself. Those were kind of the three big ones that we've definitely honed in on. And I do think, looking at it, and I don't know how, let's see, I'm just looking, do we have another meeting before March 1st? No, because that's next week. Okay. I should have looked at that before the meeting started. Sorry, everybody.
Yeah, Will's got a pretty good idea of like what, the format and kind of what we're going to say and all that stuff. Like, basically we're into the work. We have an idea of some of the big ideas that we're going to talk about, and basically we'll have something to you by the end of the year, right? It's a big problem.
Right.
It impacts workforce. Those are the big themes of what we're going to get to the legislature. And I've had lots of legislative meetings over the last 3 weeks and have shared just that. And so I think we're in really good shape. Do you feel like that, Will?
Yes, Ms. Evans. Yeah, pretty much the main thing that I kind of need this week is just a sense of what specifically to say or to suggest that the task force say it's working on, and that sort of comes from these discussions.
Yeah. Do we, and I don't know this answer, so do we need to vote on those three topics to have that included? I just don't know. This is
Madam Chair, I'm sort of jumping into the parliamentarian status here, which I'm not really. My impression as to a procedure would be the task force as a whole will need to vote formally to adopt the text of the report, or at least to empower some officers like the chair or vice chair to do so. But I don't know if it's necessary for the subcommittee to do so, as long as there's an agreement among you all.
I think we should make a recommendation for the main group to adopt, right? So like, basically our recommendation would be that we include in the report these 3 problem areas where the statute is not meeting the goals, as defined by our task force's mandate. And I don't know, maybe we could spend a little bit of time here just sort of brainstorming like how to frame each of the issues for that.
Yeah. And I think that makes sense. And I don't know if people, I know when we had done our subcommittee on subcommittees, I had done a Word document and we had literally typed it up so we were all on the same page. Would that be helpful? Or again, I'm open to suggestion here. I'm happy to just start a blank Word document.
Yeah, let's just see if we can draft, like a 1 or 2 sentence issue statement for each of our buckets.
Sure. And I see Ms. Williams has just joined us. Welcome.
Thank you, Chair. I had a meeting run over. Thank you.
Oh, you're fine. And by the way, I apologize, everybody. I got a head cold, so I'm trying to not sniffle while my mic is on.
Still showed up.
All right. Okay, I'm gonna just share my screen with a blank Word document. And this one. All right, you all see a blank Word document?
Yeah.
And Madam Chair, if you don't mind me interjecting, if anyone's watching this, a copy of this document will be posted to the website as soon as Chair Dawson gets it to me.
Yeah, absolutely. All right, so I think we can even just start. Well, Mr. Esme, you're a very good wordsmith. Why don't you get us started?
Well, let's just pick. How about we start with the permanency issue,
Sure.
since we've already been talking about that. I guess the way I would suggest we frame it is that the statute as currently constructed actually prevents DHS from making a determination on a case-by-case basis whether there is a public safety concern for this individual or not.
Regardless of how much time has passed.
Regardless of how much rehabilitation
Yep,
the person has accomplished.
yep.
Or maybe, could just frame it as regardless of how deserving the person is.
Right. Of how.
Actually, I'm sorry. I like keeping rehabilitation in there. That's probably better.
Yeah. And I also think that I think we've all sort of been talking about that the permanent disqualification list is maybe overbroad and brings in more crimes and conduct than are reasonably related to risk of harm. And I see Ben Hansen has his hand raised.
Hi, yeah, thanks. Speaking as someone who works at MDH, I'd like to broaden that statement to include our agency or just a reviewing agency.
Mhm.
Yeah, thank you for that, Ben. We kind of just
eye,
use
Ben.
DHS for a catch-all, but yeah, you're right. The 245C15 covers more agencies. It also covers county agencies, right?
Yeah, and I just kind of, since I have the floor, I can just point out on this kind of realm of thinking, there are other areas that sort of limit our agency's opportunities to maybe allow somebody to work in situations where we think it might be safe. Instead, we're kind of almost begging, we're left begging facilities to request variances in situations where, we think a person is likely going to be safe But given the way the Background Study Act works, they have to go through the whole rigmarole of having the facility request a variance, issuing authorizations for us to release private data, and just basically it keeps them out of the workforce for an extra month, or permanently if the facility doesn't really want to go through all the hoops required to request a variance. So, there's an area there for improvement, I think, from MDH's perspective that would allow the agency to limit risks of harm without putting in that time tax on all the people who really can't afford it.
How often are you finding organizations using that variance process, Ben?
We don't get a ton of variance requests.
No.
Yeah, I don't have numbers in front of me. Anecdotally, it feels like we have 10 to 15 requests like a year.
Yep.
And they really, they come in spurts. So we'll get like 4 in January and then none until April, kind of thing. But yeah, they're really not utilizing almost as much as we kind of would like them to. So.
Thank you.
Hey, Ben, can I ask a follow-up question of Ben on that?
Yeah.
So is this, I think that's really interesting that you're finding sort of areas where the set aside process is too cumbersome and the variance process makes more sense. Can you describe a little bit more like what situations that's coming up? And is that coming up I just want to make sure that we're putting this in the right bucket. Is that a permanency issue? Is it?
Right, it's not necessarily a permanency issue, but it didn't seem to fit in any of the 3 buckets. So I just wanted to while I had the floor. So kind of in the healthcare setting, what we see is, everybody who is having access to the vulnerable adults being served has to have a background study. And this includes maintenance workers and home care, like actual home health aides providing cares, and like housekeeping staff. So we'll see a situation where it's a housekeeper where they probably don't pose a risk of harm in their position, but given that they can change positions within that facility, they could move into a home care, into a care providing situation where they would probably be posing a more risk of harm. And in that situation, we have to consider that possibility and issue a not set aside. And then we kind of want the facility to request a variance where we can have them be under supervision if they move into a position providing direct care, that kind of business. So we don't see that request come through as often as we issue a not set aside for a person, but that's a thing that we have to consider when we're doing a risk of harm assessment that facilities and even the individual don't really appreciate at the time. Does that make sense?
Could we write that down as a?
I know, I was trying to figure out, this is really good, and then with my head cold, my brain's not working as well.
Yeah, could we write that down as a potential recommendation at the end of this? Because all of us have that issue, to have like a not direct care set aside, like a separate category, because we all have maintenance workers, we all have kitchen staff, all of us in this field, and we all run into this issue. And I hear what Ben is saying is that like they treat everybody like they have the potential to be a direct care staff. And my question is why? Why is that like that? Why don't we have a separate category of set aside for these individuals that are housekeeping, maintenance, kitchen staff? And so this is like an aside. I don't want to go too far down a rabbit trail, but that could be a potential end game recommendation, that we have a separate section of set aside for folks that are not ever going to be direct care, that can be a like non-direct care set aside. And then if they're going to be in a different kind of role, they would need to reapply for a direct care a different kind of job. And so does that make sense to everyone?
Mm-hmm.
It does. And I would just, for the purpose of our goal here of defining the 3 issues, I don't want to leave that out there either. I would suggest that we put Ben's issue in the process bucket.
It's kind of what I was thinking.
And describe it as one of the problems with the current process is, and correct me if you think I'm misstating what's happening here, Ben, but that it doesn't give the agencies enough discretion in issuing a set aside for non-direct care staff. And it is thus sort of shifting emphasis to the even more cumbersome variance process. Does that seem fair, Ben?
That sounds like a fair enough way to frame it, sure.
Well, and I think just focusing where even you had said, Ben, with the current process, enough discretion and that you feel the person would be safe. Again, they're not having direct care. They're qualified to do the work, whatever it might be. And yet there's not really a remedy for you, if you will, as the reviewing agency, if I'm understanding it all correctly.
Right. Yeah. You don't have a method to say you're set aside this particular type of employment. We'd say you're set aside to work in this type of facility. So if they get a job as a care provider at, say, another home care facility, or even within the same facility, they would likely be automatically set aside if we were to grant that, when really we wanted to limit that set aside to a particular type of work.
Ben, can I ask, does it have to do with the level of supervision too? That you're able to require a certain level of supervision with a variance that you can't require with a set aside?
Right, yeah, but set aside basically gives them, there's no conditions on their employment. So whereas a variance would allow us to assure that there's some sort of supervision. So even in a direct care setting, and we think for sure we would grant a variance if this was requested. We're not allowed to do that, and we place the burden back on not only the individual, but now the facility as well. And some facilities are willing and able to, take the time to do that for their employees, and some are not.
Yeah, I think that makes sense. But I appreciate what you just shared, Ben. Before we go too far, I want to go back up to the permanency issues.
Yeah,
I think one of the pieces.
Lucas, Swan has.
Tatum, I see you have your hand raised. Sorry.
Yep.
I had ran to the bathroom when we got this document together. So this document right here is what we're just putting out there to start with right now. Some recommendations of what we're saying right now.
Yeah.
Okay. So we're focusing on the how can I say, the language too, right? Like the language that's being used and user friendly. That's our part too, right? Or is that with disqualifications? Because like the language we're talking right now, a person that doesn't know or hasn't been like educated or competent in this language we're using right now, it still kind of makes it kind of, confusing for me, and I've been working with you guys. So, and it's kind of scary, for me, yeah, like if I didn't know what we're going through right now, I probably would like, man, I ain't got time for this. This is too much. This is just too much, man. They're them against me, and it just brings up those thoughts of not wanting to be let in, so it gives room for drive for going back to what you're used to, instinctive drift is what, and it's, like I said, frightening, so I think we should make it more user friendly and actually try to add in there some kind of language of trying to explain it better, trying to explain it better or alternatives, so what kind of alternatives we could come up with. Okay, you can't do this. This is what we're saying, and try to make it more friendly instead of just stigmatizing it. Because I kind of see it like oh, okay, so you can't work here. We're not gonna let you guys work here, or you're tarnishing our reputation of this program. You know, this is just my, you know, this is what I see as an individual that's affected by it. I feel like I'm tarnishing these programs, you know, and it's a horrible feeling for me, you know, just hearing it, you know. I just want to share that.
No, and I appreciate that. And I don't know if you saw, I did just add, because I want to, of course, encompass what you're saying, is that the process does need to be more user-friendly. One thing I feel like has come up before is if some sort of a form should be available, or some sort, I don't know. I know one thing that you've talked about, Mr. Tatum, is, you know, having somebody available that, you know, a contact person or somebody where you can ask questions.
You're muted, Dewan.
Regardless if it's going to work for you or not, you know, just be open to, instead of just I still stuck with me from the couple meetings back. I was like, yeah, the reputation or the tarnishing of the program and all that, you know, that's stigmatizing language, you know, and it's just, you know, it's just like I said, it has to come to a point where, okay, if you guys want people to make positive change, what are you going to give them to help them to make this positive change? It's just like there's nothing there. I don't see any of that. All I hear is, you know, all this, what I've been going through, all I hear is what pointing fingers and all that shit. You know, I'm like, okay, I'm up to it. I try to remain calm sometimes. I'll be getting pumped though, you know, so I gotta control myself with it and try to figure out and learn more about this though. But a lot of the language that's being said.
Yeah, we need to provide carrots where the risk of harm isn't so much that we can't provide a carrot for people to have that goal and that thing to look towards for positive behavior to be that.
Yeah, because it's like,
I agree,
what?
100%.
Yeah, because of what they're just permanently disqualifying me about. I don't even remember it too much. Nothing vaguely, you know. I mean, it's vague, but I know I ain't hurt nobody. You know, it's about like territorial issues, you know. And I'm like, okay, so an instance happened. So you're saying okay, let me go back and figure out what happened. You know, I had to put a story together, what happened with the situation, you know, and try to figure it out. And, you know, over time, I'm like, yeah, and it's just, yeah, it makes it real tough though. A person with low motivation is in trouble. You know, motivation for change, they in trouble.
Yeah, very triggering or re-traumatizing, you know, seem like would be the applicable descriptive words. And, you know, just to add to that too, I think, you know, I'm always talking about the accountability piece, Chair, you heard, I know, in time. But yes, just being able to make it more user-friendly so that, you know, because that's part of administration's obligation is to make procedures, policies, whatnot, clearer to constituents. And so that's a huge disturbance, it's problematic and doesn't align with what's supposed to be done.
No, I definitely think that makes sense. So, and just again, before I wanted to, if we want to add, I think there's a lot under the process piece that we'll want to hammer out, but I think the other big, if I can just go back to the permanency issue one, the other big one that I think has come up is that the current permanency list is too broad and encompasses too many offenses. And brings in or covers.
And maybe that we are exploring other states and federal guidelines, or that we're research, because we want to let them know, right, what we're doing as well. And so we could let them know that we're looking at, perfect.
Guidelines,
I mean, maybe we even want to say that like it's exceptionally broad compared to what we're seeing in other states.
Yeah.
And do we maybe even want to highlight juveniles here too? In my mind, there's absolutely no reason there should be a permanent disqualification for anything that a juvenile does, especially a juvenile as young as 12? Is that how?
Which reminds me, Josh, I've reached out to several people about having expert come in on child psychology, or I reached out to Mayo. I reached out to, I think having somebody from somewhere else come in.
Other than Perry?
Yep, is going to be really important.
Okay.
Because they won't be discounted for other work that's been done. Do you know what I mean?
Sure.
And so if anybody can be any help on that, I have a couple of leads right now. And I reached out to Mark Osler. He sent me someone's name. That's a national person. But I think that person is going to be really important, that they're tied to just clinical child psychological and social, like that area, you know what I mean? Not criminal work, like just tell us about child brain development. And so if anyone has any thoughts or contacts within that area, I think I have somebody from Mayo in Arizona that's going to be able to do it, but it's been a long haul getting.
Okay. We might just want to ask Perry too. I mean, I think asking Mark was a good idea, but like, if both of those people would be my like sort of first go-to people, if we feel like they're not going to be perceived as neutral enough, then them being able to like give us one of their sources maybe.
Mm-hmm.
So if you want, I can ask Perry.
Yep, I do feel like Perry just did the work on the felony murder law reform. And so I just feel like, and she's great.
Well, I understand your concern. That makes sense.
Yep.
And I just want to, Ms. Williams, I do see your hand is raised. Williamson, I see your hand is raised. Just really quick. I did just add, we're exploring the science behind juvenile brain development.
Perfect.
Just so that, you know, we're definitely looking at it and the science behind it and why it makes sense. But I think it's more the science and law, because I think if you look at the fact that juveniles can no longer serve life imprisonment, things like that,
yep.
I think the law is also trying to catch up as well. And I think that's important. So Ms. Williamson.
And maybe evolution of the law.
Yeah. Okay.
Yeah.
That makes sense. Sorry, Ms. Williamson.
No worries. I just wanted to, a name I would like to put out there that I could definitely reach out to is Brandon Jones, who is the executive director of the Minnesota Association for Children's Mental Health, who regularly does trainings and forums in regards to the adolescent mind and development, as well as the evolution of such. So I would be happy to reach out to him.
Thank you. And Mr. Tatum, Ms. Williamson, are you done, or was there anything more? Otherwise, I'll move on to Mr. Tatum. Okay, Mr. Tatum.
Yeah, I just had to, I got a new introduction. I just hired somebody new. I got to introduce them to the treatment courts. So to all the people. So I got to get out of this. I got to jump in this other meeting.
Okay.
I double booked. I didn't realize.
You're good. We've all been committing and showing up. So I think our group has actually been doing very well. So totally understand.
I also am going to have to jump off here in a minute. It's our last meeting for Second Chance Day on the Hill before Day on the Hill next week on Tuesday. And so is there something we're going to have to vote on here? Or do we decide we don't need to vote?
I think we decided we don't need to vote. Maybe I guess if anybody has even just 1 or 2 more minutes, I think the last thing we probably maybe add a sentence or 2 on the preponderance of the evidence and maybe another sentence under the appeal process, and there's more to do. and we can probably call that at least good for today, if that's okay with everybody. Mm-hmm. And at least I think that gives some more. Yeah, Ms. Williamson.
Well, I guess I'm not clear.
There you go, Mr. Tatum, I understand.
Bye-bye, Mr. Tatum. I guess I'm just not clear. Did you want me to reach out to Brandon? Like I said, he's a psychotherapist.
I just sent you a text message to Shonda. I would love for you to reach out to him. Yes.
Perfect.
Okay. So The, okay, so the preponderance of the evidence, I think, that we're exploring what other states and federal guidelines require, and it's, we have a lot of we are exploring, but that's okay. Federal guidelines,
Well,
with-
can we start by like actually framing what the problem is though?
Sure.
Right? Because the problem, I think, is that the preponderance of applying the preponderance of the evidence standard leads to disqualifying people for things that they didn't do. You know, we could say disqualifying people for conduct that was never proven against them or something like that.
for conduct which was never, I would say never proven. Yeah, I mean, yeah, I was gonna say somewhere in there, like just the thought of a conviction or admitted. I just proven.
I mean, we could say,
Or admitted, or
Yeah.
admitted to.
and maybe even say which creates a significant risk of innocent people being disqualified.
Yeah. Innocent until proven guilty. I'm pretty sure that's in the Constitution somewhere, right?
Well, and I also struggle that the POE, from what we know, a prosecutor could dismiss, but because somebody was charged, they may still be looking at it. There could be a really, DHS might not have all of the other information. They're not privy to, for example, email chains between attorneys or conversations as to why. It just, I think it just creates too many problems. Risk of innocent people. Whoops. There we go. We're exploring other states and federal guidelines, which seem to rely more heavily on convictions rather than can I just say POE standard?
Yeah, or rather than claims or charges or.
I think they just, to me, I think it's the convictions versus just this POE standard, which I think covers all claims, charges, things like that. I don't know. I don't know if we need to say too much more there. We're still.
Can we say that Minnesota is the only state we've found so far that disqualifies people for conduct that did not lead to a conviction?
I think it's important to share that, to state that exactly.
That's correct, isn't it? Will, did you find any other states that use the POE standard?
Not for a required disqualification, but required disqualification. Apologies. No, Mr. Esme.
Excuse me, Mr. Esme and Chair. A more politically correct way is to say Minnesota is unique, but I think we need to definitely specify that. I concur.
Realize. Minnesota unique in that it appears. Okay. I think that's good. And then just, I know we're trying to wrap up here quick, the process, just add another, there are additional items in the appeal process that we are reviewing, and we'll have other recommendations. I don't know.
Maybe even just, just do a quick list here and say some other potential problems that we're reviewing include, and then some of the stuff just off the top of my head we've been talking about. One of the things that a bunch of people have expressed interest in is having some kind of interview or, oral appeal process for people who can't write, or I don't want to frame it that way. For people who communicate better in orally than in writing.
Yeah. I think, to me, it's even just the bigger topic of feeling like there's that human contact versus it's all just in writing.
Yeah.
Sort of,
Right.
we're all.
I gotta go, everybody.
Bye, Gina.
Bye. For a more individualized review. Something like that. What else?
The process often takes so long that the job is not there by the time the person gets the set aside.
That the job is no longer available. Process is complete. Okay.
Maybe whether more people could be allowed to work pending the outcome of the appeal or the reconsideration request.
Okay. One thing that we've talked about is who really gets a hearing. I think that goes a little bit more to that interview or oral appeal process. But one thing that we've had is, some people just aren't even entitled to a hearing.
Yeah, you mean a further appeal from the initial reconsideration request?
Mm-hmm.
Yeah, maybe call it disparities in appeal rights following a denied reconsideration.
Maybe I was trying to just read this over. Maybe we already have this somewhere listed. But the due process is a civil right. So how could we word it just in honoring a person's right to due process?
I think we could phrase it just as that.
Conflict
Honoring
with the expungement statute.
What was that again, Mr. Harrison?
Conflict with the expungement statute.
Sure. Ms. Williamson?
going back to the due process line, honoring a person's right to due process, allowing resources, something along just to allow resources that they can utilize, or resource utilization in parentheses maybe.
What do you like? What do you mean by like that they actually get a hearing, or what do you mean by that?
That kind of goes to what Mr. Tatum was talking about, where there's the legal jargon or things of that nature, but just allowing resources that they can utilize so that they can exercise their right to due process.
Okay.
Lucas, on the very first line on the oral appeal, how would you feel about changing individualized to personalized?
I think that's what we're going for.
Yeah,
I like that. I really like that.
Well, and I don't know if you guys noticed, I did add include that we're reviewing include, but are not limited to. So I did add our fun jargon of we don't have to totally limit ourselves. So as we're progressing through this, if there's more we think of, we can add it.
Very strategic, Chair.
My brain worked on that part today. Okay. I mean, I think I don't know how you feel, Mr. Vogel, if this will help you as you're doing this, if we've given you a good starting point.
Madam Chair, this is extremely helpful. I suppose my main question is, would you like me to simply include this text verbatim in a draft report for the group to discuss on Friday, or would you like me to potentially massage or consolidate the language?
I'm open to whatever. I mean, to me, I think if you, as you're kind of working it in, I don't mind a little bit of massaging, but I think, or some massaging, but I don't know. I don't know that needs to be shortened or consolidated.
I'd say make it easier on yourself, Will, and just submit this.
There you go.
And
All
Madam
right.
Chair, if
Yep.
I may, just with this document, if you can go back down
Yeah.
to the due process line, just
Yeah.
some type of way, and I don't know if this would be an additional line, but in regards to the due process, if it is found that their rights, and this doesn't have to just be for due process, but just to find that their rights have been violated, that having clear next steps in regards to this will be a kind of way to include that accountability piece, where when it's found that their rights have been violated, to be able to have clear next steps of accountability. I don't know how we would want to.
No, and I think I understand what you're trying to say. It's sort of like we expect the person, for example, to uphold and to follow all of the rules, but what happens when the other side does not? I think that's what you're getting at. And that's, of course, always a difficult conversation that I have to have with my clients of the whoever it is can miss their deadlines, but if my client misses the deadlines, there's no remedy. So I get what you're saying, and I'm trying to figure out how to word it.
It goes along with like mistrial or, it's in that category, but just.
Yeah. And maybe we just say, we can just add, and a remedy is provided for when due process is not given.
I don't want to just limit it to due process, just when rights have been violated. I mean, like I said, it could be this for that line, but then an additional line to kind of resonate that, but then that it's for any rights that have been violated.
So, Shonda, can I ask? What remedy are you envisioning that there should be, other than that? The decision gets reversed and they're allowed to work.
I think it's three: is the decision gets reversed. I think it's mediation. I think it's litigation. As remedies to this issue.
You'd want someone to be able to sue the government for damages?
I would want them to, litigation could be part of that. That would be more on a severe side, but it should be part of the checks and balance in regards to adjudication. Absolutely.
Well, I do think our laws, like if you look at 1983 actions or some of those others, if there is a violation, there is a remedy. I think the bigger issue is there's often immunity, and a certain level of immunity, that I don't know that a lot of that's based in case law. I don't know.
Yeah, I don't know if it's a term that just isn't widely used, but something that comes to mind for me is like abuse of power, abuse of adjudication, something along that line. because,
When
you
we
know,
had
as,
that,
Mhm.
go ahead.
Well, I was just going to say, just, you know, as we're looking at the different areas of systemic racism and the impacts of such, you know, and I'm on a lot of different boards and commissions and tables where it's like we come up with these different strategies or different procedures and whatnot, but that accountability piece is just not there. And how do you stop the perpetuation of this? That's why we have laws in place, right? I'm not saying that it needs to be like part of a penal code or nothing like that, being criminal on behalf of the government. I'm not saying that. However, there should be something there, something substantive.
When we had the presentation from DHS a couple subcommittee meetings ago, I remember I asked about that. What I was trying to get at was what mechanisms were in place to oversee the discretional decision making of the attorneys in the background studies unit that are making these decisions. And it kind of, correct me if I'm misremembering this wrong, but I kind of think that there basically wasn't any, which, you know, from DHS's perspective, I think they're thinking, well, we've hired attorneys to do these things. I mean, this is the, you know, we have the sort of requisite level of expertise here. But I wonder if, to Shonda's point, that like sort of part of the problem here is that it doesn't seem like there is enough supervision of how the decision makers are exercising that discretion. And that if there was, maybe someone from within DHS's side would be able to better identify when actual abuses of discretion that might give rise to a civil rights violation that could be actionable happen. And then if that's, you know, when that's the case, maybe there's a requirement that the person subject to the background study be notified.
Well, and yeah, and maybe is it something even just where we're adding, as we're exploring, we can explore it further, but just simply adding another bullet point of additional accountability for the reviewing agency, or just something like that, that we keep a little bit broader, but as we're just exploring it more.
Yeah, maybe, and I don't know if it feels right, Lucas, to say, you know, for the purpose of identifying civil rights violations.
Okay. Yeah.
That simplifies it, yeah.
Ability for the reviewing agency for the purpose of identifying civil rights violations. Yeah. Okay. Good. I mean, I think, again, this is at least a starting point, and gives sort of, we're putting it all out there, and gives us really that formal starting point. So obviously we can expand as we go further, and or clarify as we go further. So, all right. Well, if everybody is good with this, I will, Mr. Vogel, I will email this to you as soon as we're done. Would you mind emailing it also individually just to the group? I understand, well, you'll put it in for the meeting on Friday, but I think since this was this group's creation, I think if they can have it sooner rather than later, that would be good.
Certainly, Madam Chair.
So if there's nothing else, we can adjourn. Anything else from anybody while we're here? No? Okay. Thank you, everybody. I know we went longer today, so thank you very much. And I will get this document emailed over in just a minute.
Awesome. Thanks, everyone.
Be
Thank
safe,
you.
everyone.